Imagine a local market trader named Stefan. He holds an annual license to run his stall. Halfway through the year, acting on an unverified rumor, the local council revokes his license with immediate effect. They offer him no hearing and no chance to respond. Unable to trade, Stefan loses thousands of pounds in revenue. He has two clear objectives. He wants his market license reinstated, and he wants financial compensation for his lost earnings. The immediate legal problem Stefan faces is procedural. If he wants to take the council to court, who exactly does he sue, and under what rules? Does he file an ordinary civil claim, or does he have to use a different legal pathway? The answer dictates the entire trajectory of his case, and it is governed by Section 31 of the Senior Courts Act 1981, alongside Part 54 of the Civil Procedure Rules. Choosing between a private law claim and a public law judicial review is the absolute first hurdle a claimant faces. File the correct paperwork and the case proceeds. File the wrong paperwork, and the court will strike the claim out entirely, regardless of the merits of the case. This strict division is known as the principle of procedural exclusivity. Simply put, a claimant cannot use ordinary private law procedures to enforce public law rights. The foundational authority for this rule is the 1983 case of O'Reilly v. Mackman. 4 prisoners were found guilty of disciplinary offenses by a prison board. They attempted to challenge these decisions, but instead of applying for judicial review, they filed an ordinary private law action. Lord Diplock ruled that using a private law claim to challenge a public law decision is an abuse of the process of the court. His reasoning was practical. Judicial review contains strict safeguards, like short time limits, designed to protect public bodies from endless litigation. The prisoners were trying to bypass those safeguards. The prisoners argued they were defending their private rights, but the court disagreed. Their right to sentence remission was a matter of state discretion, not an absolute private contractual right. The core ratio of O'Reilly v. Mackman is that exclusively public law issues must be determined via judicial review. There are minor exceptions. If a case features a mixture of private contract rights and public law issues, the public element can sometimes be raised in a private claim. A defendant can also raise the invalidity of a public bylaw as a defense in a criminal trial, a concept known as collateral challenge. If you are answering a problem question in an exam, you must establish whether judicial review is the procedurally correct avenue before you write a single word about substantive grounds like illegality or bias. Skipping this step costs you primary marks. Once a claimant determines judicial review is the correct path, they enter a procedural gauntlet. They must clear 4 distinct gates to reach a substantive hearing. The first gate is amenability. The defendant must be legally classified as a public body. This definition was expanded in the 1987 case of R.V. Panel on Takeovers, ex parte Datafin. The city panel regulating corporate takeovers was a self-regulating group. It was not created by a statute or delegated legislation. The court established a 2-part test. First, they look at the source of power. If a body is created by statute, it is public. But if it fails that test, the court looks at the nature of power. The Datafin panel regulated the entire takeover and merger market, a function so essential to the national economy that the state would have been forced to create a statutory body to perform it if the panel didn't exist. This functional necessity made it amenable to review. The true check on state power is function, not form. The government cannot shield its activities from judicial scrutiny by outsourcing them to private institutional structures. The second gate is standing. Claimants must prove they actually have a right to challenge the decision. As this text excerpt outlines, Section 31, subsection 3 of the Senior Courts Act strictly requires a claimant to have a sufficient interest in the matter to which an application relates. Looking at the example detailed here, an organization like the UK Consumer Forum isn't personally losing a license, but they campaign for industry standards. The court has to decide if a broad policy interest is sufficient to grant standing. The guiding precedent for this is the World Development Movement case from 1995, where a pressure group challenged the Foreign Secretary's decision to grant aid for the Pergao Dam in Malaysia. The court granted the group's standing based on 5 factors. First, upholding the rule of law, the importance of the issue, the absence of other challengers, the nature of the breach, and the group's specific expertise. Granting standing to expert pressure groups operates as a vital constitutional safeguard. It ensures that blatantly unlawful government acts don't escape review simply because no single citizen was directly victimized by the policy. The third gate is timing, governed by Civil Procedure Rules Part 54.5. The rule here is incredibly strict. Claims must be filed, quote, promptly, and in any event not later than 3 months after the grounds to make the claim first arose. Some areas require even faster action. Planning disputes limit you to 6 weeks, and public procurement cases allow just 30 days. Courts will only grant extensions beyond the maximum limits if the claimant can prove an exceptionally good reason for the delay. Warning tone. This is a major trap for law students. 3 months is the absolute legal ceiling. It is not a target. A claim filed at 2.5 months can still be thrown out for not being filed, quote, promptly, because courts prioritize administrative certainty and the rights of third parties relying on those state decisions. The final gate involves ouster clauses. This raises a tense constitutional question. What happens when an act of Parliament explicitly forbids the court from questioning a government decision? The definitive battle over this occurred in the 1969 Amenability case. The statute governing the Foreign Compensation Commission contained a strict full ouster clause, stating their decisions, quote, shall not be called into question in any court of law. The House of Lords countered with the nullity doctrine. They ruled that the Commission had made a fundamental error of law, meaning they had acted ultra vires or outside their powers. Their reasoning focused on the distinction between a valid decision and a void one. Parliament cannot have intended to protect decisions that are legally void. Because a nullity lacks legal existence, the ouster clause has nothing to attach to. Courts treat partial ousters differently. If a statute limits judicial review to a strict 6-week window, the courts will generally enforce it, viewing it as a proportionate balance between administrative efficiency and the rule of law. The nullity doctrine is the mechanism through which the judiciary preserves its supervisory role. It allows the courts to honor the letter of a statute while ensuring that no executive body can act with total legal immunity. Let's return to Stefan the market trader. Assume he successfully navigates the procedural gauntlet and proves the counsel acted with procedural impropriety. What exactly does he win? The overarching rule of judicial review remedies is that they are entirely discretionary. A claimant can prove a public body broke the law, and the court can still decide to grant no remedy at all. Under Section 31, subsection 2A of the Senior Courts Act, the court must refuse a remedy if it is highly likely the outcome for the claimant wouldn't have been substantially different even if the fault had not occurred. If a remedy is granted, it usually takes the form of a prerogative order. The 3 classics are a quashing order, which nullifies the bad decision, a prohibiting order, which stops future illegal action, and a mandatory order, which compels the state to perform a specific duty. To prevent immediate administrative chaos, the Judicial Review and Courts Act 2022 introduced suspended and prospective quashing orders. These give public bodies a legal grace period to fix widespread policy errors before the court's nullification takes full effect. Stefan receives a quashing order. His license revocation is nullified, and he can trade again. But what about his second demand, the thousands of pounds he lost while unable to work? In the case of R.V. Nosley MBC, ex parte Maguire, a taxi driver whose license was unlawfully refused asked for compensation. The court established a harsh reality. There is no general right to damages for pure maladministration. Section 31, subsection 4 of the Senior Courts Act dictates that damages can only be awarded in judicial review if the claimant also establishes a recognized private law wrong, like a breach of contract, or a direct violation of the Human Rights Act. Because Stefan only suffered a procedural failure, he receives his market license back, but he gets exactly 0 financial damages for his lost revenue. Do not award damages in an exam just because a public body acted unlawfully. Public law remedies are strictly corrective. They are designed to fix the machinery of the state, not to compensate individual citizens.